Good evening, everyone, and welcome to the Geneva Academy for this event on religious symbols and human rights. Let me quickly introduce myself. My name is Stefania Di Stefano, and I'm project officer here for the Geneva Human Rights Platform and PhD researcher in international law at the Geneva Graduate Institute. And it's a pleasure for me to welcome all our participants here in the room, but also online for this event. This event is organized on the eve of International Women's Day, and it's part of our Human Rights Conversation series, which is aimed at discussing contemporary issues and challenges that are related to the promotion and protection of human rights, either in Geneva and beyond, and is organized by the Geneva Human Rights Platform. For those who don't know us, the Geneva Human Rights Platform is a project of the Geneva Academy, which through a series of different initiatives, it provides a dynamic forum in Geneva for, in the field of human rights, for different actors, experts, practitioners, diplomats, and civil society to discuss and debate topical issues and challenges. We rely on academic research and findings, and in order to enable various actors to become better connected, break silos, and advance human rights. This human rights conversation in particular will explore the implications that legislative measures have on hijabs, either on banning them or mandating them, and what implications these measures have on the protection and promotion of women's rights. Following the death in police custody of Zina Mahsa Amini on the 16th of September 2022, protests in Iran have intensified, and calls for change in Iran's mandatory hijab law have intensified as well as a consequence. And this law has been enforced in Iran since 1979, and the ongoing civil unrest has brought once again under the spotlight the role of religious symbols on the protection and promotion of human rights, and on women's rights in particular. So it's a pleasure for me to have this conversation tonight with this amazing panel that is sitting next to me. We have Nazila Ghanea, who is the UN Special Rapporteur on Freedom of Religion and Belief, Ibrahim Salama, the Chief of the Human Rights Treaties Branch at the Office of the High Commissioner for Human Rights, Marsha Khan, who is a member of the UN Human Rights Committee, and Shimes Malian, who has a Master in Transitional Justice, Human Rights and Rule of Law from the Geneva Academy. Thank you so much for being here and for joining us. Just to brief our audience, the event is going to start with a conversation between the member of the panels. I will ask 2 questions each, and then we will open up for discussion, Q&A, either online or here in the room. For the attendees online, feel free to send your emails through the chat, and my colleague will then share the questions with us. Thanks again. And for my first question, I have, the first one is addressed to Nazila Ghanea. So Nazila, in 2019, a report from Human Day to the UN Human Rights Council was devoted to gender-based violence and discrimination in the name of religion and belief. And in this report, the report expressed concern over both the imposition of restricted garments, but also on the limitation on religious garments. Today, as we have just said, the issue has gained new attention worldwide. And so my question to you would be, we know that these measures do not only affect the freedom of religion, but also other rights. So can you offer some perspective on how these legislative measures affect the protection of women's rights?
Definitely, and pleasure to be here. Thank you for this invitation and everyone's interest online and here. So yes, you're right that when you first hear about Zina Mahsa Amini's case, then you might think, well, it's to do with everything except religion, because it's not the most self-evident aspect of it. But in the way that I understand the mandate of the Special Rapporteur on Freedom of Religion or Belief, it's not only freedom of religion or belief in the narrower sense, it's also being targeted for discrimination on grounds of your religion or belief in any way, right? So any discrimination on grounds of religion or belief. And the third aspect is violations in the name of religion or belief. So, human rights violations, whether it's reservations to treaties, for example, to CEDAW, or whether it is violations that, at the policy level or in law, it's in the name of religion or belief that those restrictions are being imposed on others. I think there's also a positive aspect that I suspect Dr. Salama might be drawing attention to, that just in the same way that religion or belief is used or exploited in order to violate the rights and freedoms of others, it can also be an opportunity. Maybe this goes more into Shima's, what she might share. Sorry, I'm not presuming what my panelists might share. But, in transitional justice, we have also seen religion as a platform or an opportunity for forgiveness and for rebuilding society. So, that third aspect, what comes most to mind in the human rights sphere is violations in the name of religion or belief. But indeed, there are, even in the human rights field, opportunities to reach out to religious leaders and communities to try and engage them on human rights. But that's stepping back from your question. When it comes to freedom of religion or belief, let's look at that. So is it at all relevant? Freedom of religion or belief is the right of everyone to have, to adopt, and to change their religion or belief. And it rests not on ancestry or parentage or what is presumed to be your religion or belief. And let's remember, it's thought, conscience, religion, or belief, right? That we abbreviate as religion or belief. But it's also matters of thought and conscience. So it includes non-religion, atheists, agnostics, okay? And that is broad. It's not only the recognized religion, the state religion, it's the self-identification of the person's religion or belief. So have, adopt, and change. Does the Iranian legislation recognize the right to change religion or belief? Well, particularly not from Islam to another religion. But there's more to it than that. I believe that and I think it's well established in the human rights community, that the right to have and adopt religion or belief includes the right to interpret your religion or belief. If it's a matter of conscience, then your conscience, it goes through the medium of who you are and how you feel and what you think and maybe your spiritual experiences. So it's highly individual. That doesn't mean it's not also highly engaging with the community, because in most instances, our practice of thought, conscience, religion, or belief is also in community with others. So I'm not diminishing the community aspect of it, but it also is individual, right? So you should be able to interpret your religion or belief, especially when it comes to manifesting your religion or belief. So you can manifest not only in private, but also in public, and also alone or with others. Okay. And we could go on, and I don't want to elaborate more, but what happens in the case of compulsory religious headdress? What happens is, well, especially when the state is enforcing it. And I remember, I didn't live in Iran, but I remember as an 11-year-old, 12-year-old, I would hear stories from Iran. I was living in Qatar at the time. I would hear stories about, it was well known that they would put a razor, wrap it in a tissue, and if you were wearing lipstick in public, it would be given to you to wipe your lips, and of course you would then be. So this was the early days of the prohibition, not only of not showing your hair in public, but huge restrictions on manifestation of religion or belief. Okay, so your manifestation of religion or belief is being restricted. So I don't want to presume about the religion or belief of Mahsa Jina Amini, but she lived in a system where it is compulsory to manifest religion or belief in a particular way. Iran is not only composed of 12er Jafari Shia Muslims, but even of those that are 12er Jafari Shia Muslims, which is the official state religion. That doesn't mean everybody living in that with that belief in that jurisdiction wishes to manifest in precisely the same way. And let's remember that Jina Mahsa Amini was wearing a headscarf. She was in a car with her family, but she was accused of wearing it improperly. And so is it only religion or belief? Definitely not. But certainly, at the very least, the fact that there is a compulsory, whether it is compulsory headdress or, without justification, having compulsory regulations criminalizing headdress. And perhaps there are certainly cases from the Human Rights Committee that address that. So in either direction, and in terms of allegation letters, we joined the allegation letter, the communication about Mahsa Jina Amini's case that the Special Rapporteur on Iran raised. And also, some months earlier, we initiated a communication regarding India, where high school girls in Karnataka state, the state had prohibited all Muslim headscarves. And we also, and now it's being taken to the Supreme Court of India. So, it doesn't matter which direction it goes in, it's our concern. I'm sorry, I spoke a bit longer than I meant to.
It's a perfect transition to my next question, actually, especially with the India example. I mean, we know that the wearing of hijabs is a particularly controversial topic, and it has, in fact, given rise to conflicting jurisprudence in human rights law. So at the international level, we know that the UN Human Rights Committee has underscored that the observance and practice of religion or belief may include not only ceremonial acts, but also such customs as the wearing of distinctive clothing or head coverings. This was underlined in the General Comment 22. But then we also know that the European Court of Human Rights declared that the French ban on wearing any article of clothing intended to conceal the face in a public space is compatible with the European Convention on Human Rights. And since we have a member of the Human Rights Committee here with us, which has delivered a decision against France on the issue of bans on hijabs, I would like to ask Marcia if she could maybe explain the rationales behind the decisions of the committee.
Well, thanks, Stefania, and I'd like to thank the Geneva Academy and you for organizing this topic at such a timely point, and it's a pleasure to be here to discuss the subject. You've asked about the cases that have come before the Human Rights Committee. And yes, the cases were against France, because France has accepted the jurisdiction of the committee to hear claims of violations against it. I mention this because Iran has not accepted this jurisdiction. So we can only hear these cases if states have agreed and ratified the relevant treaty. And it was in 2010 that France passed an act that banned wearing of facial coverings in public spaces. Those found in violation of that law faced criminal penalties, that is a fine of 150 euros, and 2 cases or communications were submitted to our committee in 2016, when I was already serving on the committee. We decided them in 2018. Both of the claimants in those cases against France were Muslim women from Nantes who wore the niqab, a full-faced veil. And both women were stopped for identity checks while they were wearing their niqabs in public. And they were then prosecuted. They were convicted of the minor offense of wearing an article of clothing intended to conceal the face in a public space. That was the offense under the Act. And in their submissions to us, these women claim violations of Article 18 of the International Covenant on Civil and Political Rights, that is under the right to religious freedom, as well as under Article 26, which guarantees that all persons are equal before the law and are entitled without any discrimination to the equal protection of the law. Article 18 on religious freedom also allows for certain restrictions on religious freedom. So when these cases came before the committee in 2018, we had to decide whether the ban on wearing the niqab was within the authorized restrictions in Article 18. And those restrictions in the covenant are that there can only be restrictions on religious freedom if the restrictions pursue a legitimate objective, if they're necessary to achieve that objective, and if they're proportionate and non-discriminatory. France claimed in its arguments to our committee that the ban served 2 legitimate objectives. First, the protection of public safety and order, and second, the protection of the rights and freedoms of others. The committee, however, found that first, France didn't demonstrate that the limitation of the women's freedom to manifest their religion and belief by wearing the niqab was necessary and proportionate within the meaning of 18.3. And second, the committee didn't accept France's claimed objectives as being legitimate. Third, even if they were or would have been legitimate objectives, France had not demonstrated that the ban was proportionate to the objectives or that it was the least restrictive measure required to achieve the objectives. And in coming to those conclusions, we observed that the ban was a comprehensive one. It was a criminal ban on the veil, which restricts Muslim women's rights to manifest their religion. With respect to public order and safety, we noted that the ban was not limited to contexts where people need to reveal their faces, but rather it prohibited face coverings in public at all times. And there were some exceptions in the law, in the 2010 law of France, for example, regarding sports attire. And France also didn't indicate how wearing the full face veil in itself poses a threat to public safety or public order that would justify an absolute ban. When France made their arguments on the protection of the rights and freedoms of others, they failed to identify any specific rights and freedoms that were protected under the Act. They made a general argument. And they didn't explain why the presence of veiled women in public might undermine the rights and freedoms of others, when other forms of face coverings exempt from the law would not. So this wasn't part of their argument. And a good part of the argument of France was based on the concept of living together, or vivre ensemble, which suggested that people need to see one another's faces for this purpose. So the committee found, in relation to vivre ensemble, that the concept was too abstract to justify the ban. And in our decision, we noted that despite the way the law was framed in a seemingly neutral way, it clearly had a disproportionate impact on Muslim women, and that it amounted to indirect discrimination under Article 26. We also recognized the potential for this French law to disadvantage the very women it purported to protect by confining them to their homes, by impeding their access to public services, and by exposing them potentially to abuse and marginalization. So ultimately, we found that the ban constituted intersectional discrimination based on gender and religion. And as I think most of you know, there are 18 members on our committee. Some of us wrote concurring opinions, even strengthening and furthering the decision. I was among them. And 6 of us wrote a concurring opinion. We were also of the view that the practice of wearing a full veil is discriminatory by itself because the practice has allowed men to subjugate women and has prevented women from occupying public space on the same terms as men. We also accepted that France was entitled to take appropriate measures to address the practice of veiling because of its discriminatory impact on women. But the blanket ban on full-face veiling and criminal sanctions, imposing criminal sanctions against women who the ban is purported to protect, was not appropriate in our view. France had, and we said this, failed to demonstrate that less intrusive measures would not have achieved the aim of preventing or preserving equality between men and women, while also respecting other rights, such as the right to privacy, autonomy, and religious freedom of women themselves. So that was the thinking, the thrust of the decision of the majority. As I said, we have 18 members on our committee, and 2 members dissented. One of them asserted that the niqab is a symbol of the subjugation of women, and that therefore makes it a justified intrusion into religious freedom to impose a ban. The other dissenting member believed that the ban was necessary and proportionate to the objectives in light of the rising number of terrorist attacks in France. So one member said that. So those were the outcomes at the Human Rights Committee in the two cases against France, and also some of the reasoning that we finally decided on.
Thank you. Thank you so much for this very detailed explanation of the decision. I think it's very useful to see, the different layers through which the decision was reached, but also, dissenting opinion, concurrent opinion. It's very interesting. I want to take the opportunity, since you mentioned the concept of living together, this was the winning issue in the European Court of Human Rights case. So may you briefly explain why there is a difference of views between the Human Rights Committee and the Court of Human Rights, the European Court of Human Rights, on the same issue?
Yes, there was a different conclusion,
certainly,
by the European Court of Human Rights. And the European Court of Human Rights has in fact upheld state restrictions on Muslim women's dress in every country from which it has heard these cases. Not only France, but also Turkey and Belgium. And when one compares, I would say that the court is more willing to accept infringements on the right to manifest religion by wearing religious symbols than the Human Rights Committee. I think that's clear from our outcomes. The Human Rights Committee doesn't offer states the same margin of appreciation. In the French ban cases, I should point out that there were similarities between the committees and the European Court's findings. For example, on the limitation of religious freedom, our committee and also the court found that the French blanket ban of face-covering garments was an interference with the claimant's freedom to freely practice their religion. That was a similarity between our decision, our reasoning, and the European Court's reasoning. And the court and the committee also reached similar outcomes on the legitimacy and proportionality of the aim of public safety. Because the European Court said that despite the margin of appreciation that they apply, we don't, it found that an intrusive measure such as a blanket ban can only be considered proportionate for the sake of public safety if the state party demonstrates that there's a general threat to public safety, and France had failed to do so at the European Court. Also, the court decided that the need to identify individuals in order to ensure the safety of persons and property, identify in the way of uncovering in order to be able to see them, to combat identity fraud, and ensure the safety of persons and property, that those aims could in fact have been attained less intrusively by France. They said the same result could be achieved by obligating wearers of the burqa to identify themselves where a risk for the safety of persons and property has been established. So there are many less intrusive means. Where the court and the committee had different views was with respect to vivre ensemble, the concept of living together, in terms of its legitimacy and its proportionality. The French government argued that the aim of the ban was the respect for the minimum set of values of an open and democratic society, values such as respect for equality between men and women, respect for human dignity, for the minimum requirements of life in society, and the concept of living together. These were the elements, the threads of the argument. Vivre ensemble, they claimed, was about open personal relationships, and so the showing of one's face is an indispensable element of interaction in interpersonal relations, according to the French government's argument, and therefore it was a legitimate aim. So the European Court referred to carrying out a balancing act, weighing religious freedom against the rights and freedoms of others, linked with this concept of vivre ensemble. And in striking the balance, the European Court recognized that the state, France, enjoys a broad margin of appreciation, and the court gave more weight to the principle of vivre ensemble because a choice had been made by France on that principle, on that concept as a democratic society. French people had chosen this as the prevailing principle, and they accepted it. So the European Court concluded that there had been no violation of religious freedom by imposing the blanket ban. But I would point out that, as with the committee, there were dissents when the European Court decided, and two of the judges of the European Court partially dissented. They said that living together was very general, that it was vague, that it was abstract. So there are differences between us, but there are also some similarities in approach.
Thank you. Thank you very much. And also, through these questions, we've seen different themes already emerging: equality, discrimination. It's not only limited to religion. And this again leads me to my next question to Shima. Do these measures, or the mandatory hijab, but also the ban on them, only concern religion? And how would these measures interact with patriarchy and politics?
First of all, thank you so much for having me. I also want to say something about the ongoing poison attacks that have affected more than 1,000 school years back home. And I want to say that this Women's Day truly belongs to them and many others who have fought in this war since the beginning of the uprising. So for answering your questions, I need to explore briefly the nature and history of hijab in post-revolutionary Iran. And I think there is a lot of literature on mandatory hijab, when I think there is a consensus that this is the intersection of patriarchal, religious, and state oppression. In Iran, and during the last century, there has been veiling and unveiling happened 3 times, been regulated 3 times. And I think the roots go back to the medieval time when the Islamic jurisprudence, a legal system, was developed in which Muslim social behavior, including gender relations and sexual conduct, was governed. So the religious categories of morality, and modesty, and so on, were disproportionately imprinted onto the female body. So to protect the society's morality, rules on attire, mobility, and sexuality began to form. But in Iran, and before the Islamic Revolution, in a turning point, the female body became the battlefield of another war, a binary between modernization and Islam. It was in the beginning of the earlier 20th century that through the process of modernization during Pahlavi dynasty, the decree of banning all Islamic veils was enforced on women. And this politicization of the female body continued after the Islamic Revolution in a different sense. The foundation of the Islamic Republic following the 1979 revolution materialized partly to Western imperialism and its cultural hegemony, in which the modern woman as a symbol of West was represented as unveiled, publicly visible, and sexually free. The regulation of the female body became instrumental to the politics of the Islamic discourse. Actually, the post-revolution Islamic discourse saw hijab as a counter strategy against the Western cultural hegemony. And we see that female body has become the battlefield of this new political structure in post-revolutionary Iran, and rendering the female body a site of the state physical and disciplinary violence. And when I say that, I mean it's not only excluded to hijab, but many different rulings that target the female sexuality. And I can name a few, but hijab became the self-identity, the self-image of the current government. So I think this is important to see how hijab is violating women's body autonomy, personal autonomy, many different aspects of their cultural rights and civil rights. Yes, I think that answers the question.
Thank you. Yes, indeed, it does, and it's incredibly interesting. I think we could spend more time on this specific topic. My next question is for Ibrahim. Ibrahim, you are one of the initiators of the Faith for Rights discussions and framework. And my question is concerning this OHCHR framework. Where do you see the role of faith leaders in this conversation? I mean, she must have been discussing the fact that female bodies have become a battlefield between, politics, religion. So what is the role of, or where do you see the role of faith leaders in this conversation, and what could their role be in promoting women's rights?
I think, as Nazila said, religion have been predominantly looked at as the source of the problem.
Yes.
Which is not entirely untrue.
Yes.
However, there is another side of the same story, which is that faith actors are probably best placed to influence far more deeply the thinking in societies. And we have seen this on occasional, not to say opportunistic, moments where the special procedure system and the treaty body system needed specific action from faith actors, so the outreach for that in particular. So there has been a phase of total deliberate ignoring each other because of the perceptions and the ideologies and the complexity of the religious sphere, and because of secularism as well. But at the same time, this didn't stand the testing of the truth and the need to collaborate on many issues. And the Faith for Rights framework starts from this assumption that those are two value systems that do not talk to each other, and that they have a lot to engage on, and they need each other. So instead of the sporadic attempts to deal with religious aspects of human rights controversies, why not have a narrative that kind of provides both a common platform? So the essential idea of Faith for Rights was just reading the precedents of where the two spheres that do not talk to each other needed each other, and try to expand on what I call the double convergence. What's common between all faith traditions? Because as Nazila said, the definition of religion or belief in human rights law is not limited to the commonly perception about religion. It's much wider than this. What's common among them, and what's overlapping between them and between the human rights normative framework. I would say that in this particular case, just to give an example, why and how a global approach to religion, which is not only freedom of religion as such, what does it entail and what it does not, but in the larger sense, as Nazila said, the violations in the name of religion or belief, but also the missing benefits that faith actors could bring if they are equipped with human rights tools. So we try to open the space. This framework belongs to the more than 300 faith-based actors and civil society and human rights advocates who are interested in freedom of religion or belief, whether as such or in the larger sense. Nazila was among the key actors at that point in time, and she saw how much there was a need to fill numerous gaps and to connect the dots between both tensions and complementarities. Just to give two examples that relate to this particular case. I think the missing two elephants in all what we heard from the excellent three presentations are two words: instrumentalization and coercion. It's whether or not a religious symbol is instrumentalized whether by populist politicians or by fanatic extremisms, or by political parties that instrumentalize religions to achieve electoral gains. And the other one, whether women's consent and choice was genuine or has there been coercion. And I think there is a missing clarity in terms of the standards of human rights law that would distinguish between an acceptable role of religion in politics, both nationally and internationally, because you can find many legitimate Christian democratic parties that did inspire from faith traditions along history, and this is perfectly acceptable. But where is the limit between this and instrumentalizing religion in nullifying people's will or instrumentalizing them to move, exploiting religious emotions, which are among the deepest identity factors for human being? And the second element is coercion. And this, I know this for a fact from my knowledge of the Muslim world. There is a very difficult to identify kind of collective social pressure. In the case of Iran, it's much more obvious because there was a revolution, a change of regime, and all of a sudden you find somebody imposing and using women's freedoms as a battlefield or as an area where they mark their ideological stroke theological territory at the expense of women's free choice. But there are much more subtle ways, like the Muslim Brotherhoods, where the slogans of them as a political party that for at least a year they ran the country. I know best in Egypt, but then they were much smarter. Not that smart because they didn't last more than 12 months, but this is another story. But the idea is that big part of their advocacy was based on smartly manipulating religious feelings. I would relate this to the doctrine of Putin about the decading morality in the West. It's not very far from this. So instrumentalizing values and mixing ideology with theology with law requires some missing thresholds. And I think that the human rights movement, and at that time, Marcia, it was Michael O'Flaherty who was a rapporteur on the General Comment 32 or 34. And at the same time, he was part and parcel of the Rabat/Beirut process. So he linked the dots, and you will find most of the elements of the Rabat threshold that distinguish free speech from hate speech in the same General Comment 34. And again, your predecessor was among this process. So I think the only way forward is a combination of approaches, because and I think Marcia explained it very well, that the legitimate disagreement on the application in a particular case can come from only one variant in the reasoning, in the legal reasoning. But the more you have multi-human rights mechanisms approach to the same issues in advance, because it's very difficult to clarify a rule when you are empirically working on a specific conflict. And we have seen that there was divergence. But if in advance this effort of trying to I was saying it's a gray zone and a hot potato, so it ends up with a gray potato, which is not appetizing at all. But you cannot approach it at the table. You need to look at the ingredients at the very beginning. So I was just speaking to Nazila before we start about an event whereby one could scratch the surface. Are there possibilities to define a threshold for both manipulation of religion for political aims that should be prohibited, and on which ground could it be prohibited? And secondly, the issue of coercion. How do we verify without procès d'intention, without replacing women? How do you verify that this is their free will or societal pressure?
Thank you. Thank you very much. And I mean, since you were discussing this with Nazila just before, I mean, my next question is precisely on your mandate. You've just taken up the role. You will be presenting your report on Friday. And my question is, what issues have you already encountered, identified in, this area, the topic of our discussion tonight? And how do you plan to address them during your mandate? Maybe, this definition of thresholds on coercion could be one of the topics.
That's a very good one. But, already from what was shared on the panel, we see, if we just consider women and Iran and France, we see that when there are violations in either direction, in absolute restriction or in absolutely compulsory wearing of headscarves, it doesn't only impact freedom of religion or belief. As you were saying, it's also discrimination, it's also movement, it's also rights to health. In Iran, it was a whole host of laws and policies that go around it. The prohibition of women from studying certain subjects at university. So, I've put in this report that probably one of the best examples of a human right that is deeply interrelated and indivisible along with other rights has to be freedom of religion and belief. If we purely look at the discrimination on grounds of your thought, conscience, religion, or belief, already we see that all human rights are implicated. All of them are at risk when you're targeted, right? But also in other ways that, there aren't many examples where a religious minority group often are targeted purely on grounds of their religion. There's a clear animus and objection because of the existence of that identity, that religion or belief. We see that. But when that happens, is it only their freedom of religion or belief that is at risk? No. A whole host of rights, from economic, social, civil, and political, all of them become at risk. And so it hardly ever stands purely alone in the human rights framework. What am I addressing? In this report, I want to insist that freedom of religion or belief is universal. And at least I trace in various instruments that we see the commitment to it. And I say, if we say that it's Western, well, actually, if we think about the impulse and the history and civilizations and claims and claimants, actually we can say that freedom of religion or belief is an Eastern human right. It's not Western. I mean, there's no real deep justification to call it Western. Okay. And secondly, I try to acknowledge that this has become a very active field. There are many different actors that are working on the platforms of religion, religious communities, and freedom of religion or belief. These three are not the same. They don't always advance the same objectives. They don't always all advance freedom of religion or belief as a human right. But there is a lot of resource and engagement and activity. And, we have to figure out a way of working together better. We have had at least 130 years of formal interfaith engagement. Are our tools and our understandings more advanced now than they were 130 years ago? In what way? Are we achieving the objectives? Are we collaborating sufficiently? Do we have enough clarity? These are some of the questions. In the next report, I want to look at the variety of actors that can be pertinent in either restricting or advancing freedom of religion or belief. Yes, in human rights, we talk about the state and the obligations upon the state. And that, of course, is the framework also of the mandate and has to play an important role. Whenever there's a communication with the mandate of violations, what do? We write to the state and ask it to explain how they see it, what is happening, whether the facts that were put to us were correct, right? But nevertheless, where there are violations of freedom of religion or belief, we still see the champions of freedom of religion or belief, the prison officer that is generous, the neighbor that saves your life. In a country that has many restrictions, there is the part of the country that is more open to diversity. There is the municipality that is still doing good work. There is the mayor that seems to be, a light in a whole arena of restrictions. So I want to bring to light the variety of actors. Parliamentarians are just one of them. NHRIs are another. I'm not clear about any coordination of national human rights institutions and freedom of religion belief. So both in terms of restriction and advancement, I want to sort of break it down a little bit to observe the other actors and how crucial they can be.
Thank you. Thank you very much. Ibrahim, now another question for you. This time, in light of your other role as chief of human rights treaty branch in the Office of the High Commissioner. What do you think is the role of treaty bodies for the promotion and respect of women's rights? And is there any space for treaty bodies to collaborate on the issue also with other mandates, special procedures, and other parts of the human rights system?
There exists a collaboration.
Yes.
It's not enough. There is a will, but there is no time and there are no resources, unfortunately. I remember when I first joined the Office of the High Commissioner for Human Rights, we had the luxury that the Coordination Committee of Special Procedure System, we could manage its date to collide, to overlap with the meeting of the chairpersons of the treaty bodies. And this was a huge opportunity for them to collaborate. Now it's really on a case-by-case basis. Of course, I will say some examples. For example, on CEDAW, which is the main custodian of women's rights within the system. The system in general is a victim of its proliferation stroke expansion. So the more you expand protection, the more you create difficulties and tensions in terms of collaboration. Felix will know a little bit about this through the platform of Geneva Academy on Treaty Bodies, where it offers them this space and it shows how much this space is needed. But the system is growing organically. When I say the system, it's both the special procedure system and the treaty body system. And collaboration becomes an individual uphill for them to find the time and to really collaborate, let alone the difficulty. You need time in order to reconcile approaches, and there is a legitimate differences in views in most of the cases. There's nothing arbitrary here. But so far, for example, we find that the more tense the situation is, like in Afghanistan, it prompted this impulse and the need. So you find that CEDAW has acted, created a task force where they engaged with the Special Rapporteur on Afghanistan, the Special Rapporteur on Violence Against Women. They conducted joint missions. But this is because of the flagrancy of the Afghan case in terms of undescriptible violations for women's rights that are really prehistorical. So, but when it comes to normal situations, for example, in this very room, I remember, I don't know, you were there, Marsha. Yes, you were there. In this very room, we had this discussion between members of CEDAW and members of the Human Rights Committee about this case. So it showed the need and the intensity of different perspectives, which is absolutely legitimate. So I consider the Faithful Rights and the Rabat to be perfect examples of a long term, because we designed the space and we took the time. Rabat took 4 years of collaboration between what I used to call at that time the trio of rapporteurs relevant to the issue of hate speech. So it's cultural rights, it's racial discrimination, and freedom of religion. And the three of them had to work together, because also the Human Rights Committee and CERD were the two committees that have explicit provision on hate speech, not excluding others. So all of a sudden, the thematic approach helps creating objective alliances in thinking. If you go about it organically, it's a nightmare. I'm struggling, and Marcia knows this very well. She's part of that struggle, Felix as well, to try to make even the treaty body achieve the fulfilling prophecy of calling it a system, which is 24 times repeated in 68 to 68. But it's very hard to act as a system because they don't have the time. They don't see each other. It's ships passing in the night, like Philip Elson called it in one of the articles. So there are efforts, but they are not enough. I have a full list of examples that I can share that Brita kindly prepared, which shows that there are, but within these examples, Brita, there are things that go deep into achieving something together, and there is only gathering to try and achieve something together. So I would say that the Rabat threshold is a very concrete result. And maybe when I compare the cases that you kindly compiled, and both Rabat and Beirut, it's the element of time and the political investment in the long term. You cannot achieve synergy on complex, substantive human rights controversial issues overnight, or merely by an exchange of email between this rapporteur and that committee. It will never happen. We will only give lip service to synergy unless we create the space. And it's a dilemma for the human rights architecture at large. One of my very personal views, so not representing anybody here, but probably because I'm influenced by my in an ancient history when I was a member of the subcommission, when at that time it was a genuine think tank, not just a think tank that cannot think for itself. It had to be the Human Rights Council to tell them what to think about. So at that point in time, you had only one component of the architecture which had a global view on human rights. And by definition, this allowed them to bring the system together to some extent. I have to confess that this will indicate how long I've been in the system, that when I joined, it was only 6 treaty bodies. And now it is 10. And if you count the addition, the optional protocols, they are more than 15. And if we count the Right to Development Drafts Convention going to New York soon, so it's endless and it's going nowhere. So how much the system can continue to pretend through just meetings and discussions that it's working as a system when it's actually missing a lot of its impact because it's too big to be coherent.
It's not very hopeful at the moment, but hopefully there will be time and space to advance, create a new Rabat framework also for women specifically. I have a final question for Shima, to add complexity on what has already been a very complex issue so far. My last question for you is, do cultural relativism, decolonial, anti-universalist, academic or non-academic discussions hinder the activism against mandatory hijab laws?
Well, yes, I think it's a very important question. And I think since I've been studying in Geneva, I had some confrontation that were very interesting in terms of, for example, one of my confrontation was that between one of my professors and a colleague, that they were discussing whether they are entitled to speak about women in Afghanistan if they are oppressed or not. And I was very surprised of the conversation. I could not imagine that this is a matter of entitlement for people. So I think it's true. In the past decades, academia has engaged extensively in criticizing the universality of human rights and the colonial and imperial power of international law, as well as white feminism, and engage extensively with cultural relativism and cultural politics. And I think I'm aware of the necessity and the significance of these discussions. But also I think they inevitably produced some narratives and discourses that hinder the human rights activisms in a geography like Iran or Afghanistan. For example, we can see that the binary of Western, un-Western that you mentioned before, I think this is something that Islamic Republic relied on for not fulfilling the human rights violation that they had, based under the justification that we want to preserve our cultural values or religious values. And I think this narrative has been reinforced by this academia, and we see more we see that reservation into the conventions based on the conflict with the Sharia law has been justified by this, and backed up sometimes with academia in this sense. We could see that, for example, exercising basic rights of Afghan women has been actually considered as a westernized style of living in asylum cases. And I can go on and explain more, but I think the point is that I think we should rethink about this, and I think it could be problematic of thinking of the human rights violation that happening here and there as Western on Western, and in this matter, I think we are leaving some people behind. On another note, I think also because of the Islamophobia that exists and the oppression that Muslim women in West experience, also I think it's really not easy to speak about the religious oppression that's happening back there, because sometimes speaking about the really religious oppression, it might cause more Islamophobia, and people want to avoid that. So I think also this is a space that we should think about how we can interact with both of the aspects that not cause more oppression for women back in Iran and Afghanistan, or not more discrimination for Muslim women in West. And I think, yeah.
Can I add one word here to agree with what Shima said? One word we can take from the early years of the revolution is Gharb Zadeh, or somebody that is captured by the West. It's been translated into English as West toxification. So somebody that has, but I think it's quite telling, you've become toxic because you have been enraptured by the West. So, the sort of clash is seen as quite vividly.
Yes, exactly.
Thank you. Thank you very much. I think I will stop here with my questions, and I will open the floor for question either here in the room or online. Yes, we have a question. Please.
I have a question for each Marcia and Shima. For Marcia, has it been considered that machine identifications under a mosque can take place, and that would then put the company or the institution that is able to do this in a superior knowledge position relative to the other people sharing the space with those people? And to Shima, why now? Why is this happening now? And I would like to also make a remark to what Ibrahim said about sudden or gradual coercion. Now we can see when there's a sudden change, then we can see that it's coercion. But if it happened along centuries, is this not also coercion? And parallel to that, doesn't that mean, as an extension to that, doesn't that mean that we should question every one of our convictions? Because we don't really know if we have not actually been coerced into thinking this. And this is valid outside of religion, also. I also read recently that girls in France, after that decision, after the ban, they were more inclined to take up studies, etc., without the hijab. So what about that?
Thank you. Thank you very much for your questions. Anyone else from the room or online? Online, we have questions.
Online, there are a couple of questions, and also if I may come in for a technical issue. I don't even know whether my voice is here, but when we ask questions on the floor, if we can raise our voices, I think our online guests could not hear questions that loudly. Anyway, we have a number of questions, yes, from our online participants.
Maybe we can take a couple of round of answers and then.
Perfect. They're not aimed at any panelist as such. Okay. I'll just read out a few. So firstly, in Iran, women are protesting not to wear hijab. In India, women are protesting to wear hijab in educational institutions. Should religious rights be described in constitutional law of any country? And this participant also follows up with a second question, that is, what is the role of the Constitutional Court on policies mandating religious beliefs? So that's one set, and maybe I can read out a second one.
Yeah, and then
so of course, participant, thanks for the fascinating contributions. And she says a lesser discussed intersection today is religion and expression. Once again, the difference between France and Iran is startling, yet there are similarities between extreme protection of religion, that is Iran, and the reluctance to engage, and that is the French laïcité. And both affect freedom of religion and expression. What, in your opinion, are the factors which render the legal frameworks susceptible to their use for domination, one way or another? There are some more, but we'll keep it for the second round.
The second round. Thank you so much. And I don't know who wants to start with Marsha. Okay.
Thanks for the question about whether it's been considered if how machine identification works through the veil and what the implications of that would be. I think, the Rights Committee deals with cases. We deal with the cases that come before us. So that, in a way, at least in terms of our juridical function, deciding communications from individuals on human rights complaints, that focuses our scope to the facts of those cases that happen to come before us and that we focus on. So this hasn't been something that's come up, and it also is an area that the Human Rights Committee hasn't pronounced on yet in terms of privacy or in terms of other rights. Now, having said that, I didn't mean to give the impression that the only function of the Human Rights Committee is to decide on individual communications or decide these cases, because we also have other opportunities. And we've been talking about one of our standards, the general comment that deals, Michael O'Flaherty was involved in, that deals with this subject. But there is an opportunity for the Human Rights Committee to go forward and develop a new general comment. It would be General Comment 38. And I know that civil society representatives have been speaking with me and other members of the committee about different areas that are crying out really for guidance in a general comment to state parties. And one of those issues is privacy, and how privacy should be dealt with in order to facilitate that right in countries around the world. So no, we haven't dealt with that, but I think that there are different ways that we can maneuver going forward. We can also make use of the other mechanisms, as Ibrahim has said, in some of our other functions. We've been speaking about Afghanistan. Afghanistan is on the list of the Human Rights Committee as a country that we're going to review their progress on civil and political rights. So this is an opportunity for us to use all of the rich and useful information from special rapporteurs, from faith leaders, from civil society. So there are other ways that we can cross-fertilize our work and join forces across the system through our country reviews of countries like Afghanistan. Just a point about the right to education that was also raised, and your mention that, if I understood you correctly, that the number of girls going to school without a hijab increased. I have other research that suggests that after the ban, the gap in secondary school attainment between Muslim and non-Muslim women increased. That means more girls stay home. And that the dropout rates for Muslim women compared to that of non-Muslim women was higher. But I can't say more how it was measured.
Thank you. I don't know, any other...
Just a quick reaction to say that it's a bright question, what you described as, I'm giving a name to your phenomena, which is implicit coercion, étalé dans le temps. And I think that's precisely what is missing in the religious sphere, the critical thinking. And this is one of the added values of the joint action by rapporteurs and treaty body experts when they work in an extracurricular manner and outside the scope of the limitations of time and translation and services that we can provide. When they do this, in fact, you have at least 4 among the 18 Faithful Rights Commitment that deal with critical thinking from different angles, including the commitment to self-monitor the religious teaching curriculums, including the duty not to oppress any dissentant religious views, no matter how sacred the issue has been. And the example in everybody's mind is Naguib Mahfouz and Nasr Hamad Abu Zaid, the famous cases where he was separated from his wife. The brilliant question about Constitutional Court in Egypt, the High Court, Mahkamat al-Naqd, separated a man from his wife because of his writing on religion, were considered to be taking him to be excommunicated. The equivalent is takfir in Arabic. So he was excommunicated by a court of law. So there is clearly a lack of clarity. And as Marcel just said, the more the system of human rights protection, and it's much easier said than done, acts in a complementary manner as a Swiss clockwork or as a toolbox that really functions, the better it is. At present, we are not there yet. We are struggling to achieve this point. Very quickly, also the question of I love the comparison between France and Iran, because again, one of the commitments equally disqualifies or prohibits or asks to work against the two extremes of state religion and doctrinal secularism. So these are really two extremes, and they show that there is a need for a clarification of the standard in between. And the underlying ideological and political fears in the case of France, and the opposite fears in the case of West
of toxification.
West of toxification. Very difficult to pronounce, but very easy to understand. It's exactly the same. Separatism in France, it's the same treatment of the West as toxic. So ideology and politics are underlying, and that's why we need criteria to separate them from religion while allowing the value systems of all faith traditions to be freely expressed. Nahla Haidar used to say, as a Muslim woman, I shouldn't be compelled to choose between my religion and my rights. And this is absolutely a necessity that doctrinal secularism puts women in this impossible choice.
I don't know if Nazila, let's see if the panelists have any other contribution, then we open up for a new round of questions. So please.
Sure. There were, first of all, I want to say that although I think the comparison between Iran and France, and I also spoke about it, is valid in terms of the contrast, I would not say there's parity. And I just want to just say that, you know, we're talking about 43 years of structural, institutional laws and policies that are very, very intrusive. I'm not justifying or lessening the impact of the secularism and living together, and how, you know, suddenly we have a term that comes in and compromises human rights. I mean, that doesn't work for me, right? I mean, if you're going to, we have limitations. The limitation grounds are both laid out in Article 9 of the European Convention, also Article 18 of the International Covenant on Civil and Political Rights. Don't bring in a new term and tell me that is the reason. It just, you know, let's use the terms that we have and develop a jurisprudence that is helpful. Okay, the European system is different in margin, etc. But I just want to make that general point. Secondly, what should constitutions do? I mean, what I don't understand is how many states we have that fear freedom of religion or belief. They survey it, they monitor it, they control it, they classify people. They refuse to accept that somebody has converted, or that they fear that people communicating openly on matters of religion or belief. I mean, when people converse openly, first of all, I think views should be heard, and not just religious views. Other views should also be heard. We also have a bit of an environment of silencing, or certain views will not be tolerated to be heard. If they're not heard, they will be driven underground, and they will stew, and you know, they won't disappear, right? So we should allow for vigorous engagement and debate, and be more able to hear views that completely contradict and contrast with our own, and be able to have discussion about it in society. So first of all, let's get rid of the fear. And then what should constitutions do? They should uphold freedom of religion or belief and human rights. And, you know, if there's a reason why that is dangerous, let's talk about it. I mean, what really is dangerous there? With freedom of expression and freedom of religion or belief, I think they don't have to, we have to look at the facts of the case. I think Shima brought a very important dimension to our discussions today, which also Marcia reinforced, is that when you look at the facts of the case, when you look at domestic law, let me just talk about in the law of England and Wales, there are cases about manifestation, and sometimes the girl child, you know, the girl who says the shalwar qamis Muslim school uniform alternative is not good enough. It needs to be more compliant. The girl that says, I want to wear a chastity ring in school, and that's part of my belief. And even though jewelry is prohibited, In all of these cases, or the Sikh girl in Wales who wants to wear the Sikh bracelets, and they say, again, jewelry is not permitted. And she says, but this is a manifestation of my religion or belief. It's not jewelry. It's not just jewelry, at least. What courts are able to do is to ascertain if it is under pressure. Is there duress? Is there a father, a brother, a pressure point on that person's expression? And then they will consider that. So it's not that we are blind to that possibility. It's just that when we're looking at concrete cases, we can deal with that. That is one of the factors that must be entertained. But to say that a particular symbol is only ever political, which laws say, they say, the headscarf is only imposed by men, it is only a political symbol, and therefore it should be banned. Or it is only ever worn for other reasons, not for manifestation of religion or belief. Are we really going to sort of make a universal judgment about a particular expression? And would we do that in other arenas? So a factor that must be considered and brought in, but not one that we can just assume without closer attention. Maybe Patricia disagrees and this gets fun.
I agree that I'm always interested to see the importance that women's clothing has, but men's clothing has none. Absolutely none. Or whether they wear a beard or have to wear beards or not is not discussed.
Sometimes.
Or rarely in comparison, I think. But I would like to come back to what has been said about the system, Ibrahim, what you said. Listening to Marcia and learning that there might be a general comment on privacy, why couldn't this be a joint general comment, general recommendation of more than one or two committees together? But why not? I mean, privacy is the same problem for all the treaty bodies practically, with some adaptations for maybe for the CRC, but or CRPD, there might be some technical difficulties, but why not try and work in common on such a grave issue? That was that's why I wanted to intervene. And then I would like to ask another question, and that's regarding Afghanistan. Yesterday I was at the opening discourse by Madeleine Rees of the Women's International League for Peace and Freedom, and she spoke about the role of the UN in peacekeeping operations and in all sorts of places. And one question that she asked, I found completely fascinating, is why does the UN stay in Afghanistan when the Taliban have been eating up every single tiny right that was left to women and girls, and these have been destroyed progressively, very cleverly, because every time the Taliban bring a new restriction, the whole UN system that go, and we stop breathing, but then they stay in. And what would it be? I mean, would it be worse for the population, including for the women, the female population, if they just said, that's it? The violation of women's rights are so gross that we will not give any help for this regime.
Thank you. We have another question behind, and then yes, one.
I have a kind of legal, technical question, maybe. But you mentioned the concurring opinion that the person considered. You mentioned terrorist attacks and things like that. And I was wondering how possible it is to consider the social context in decision making at HRC level, and on the other hand, if the rise in xenophobic and racist attacks is also equally considered.
Thank you. And one in the back, and then we go for a last round of answers. Yeah.
Thanks. Thank you for organizing this wonderful panel. I have questions to Shima specifically, but also to other panelists, as to some extent representing the UN system. And well, I'm working on the part of civil society, but my everyday work is with the UN. And at the same time, I'm also doing a research trying to keep the belief and hope in the UN system. But to be honest, while listening to Mr. Salama's explanation of why treaty bodies cannot agree and how resources are not enough, I'm just thinking why Iranian women who are coming to the streets, they're not talking or speaking about not enough resources, and maybe to some extent being critical to the UN system. My question is, compare maybe to the, I don't know, European system, UN system has less resources. Compared to, I don't know, Human Rights Council, probably treaty bodies have less resources, and we know that it's more and more countries, more and more working methods. But at the same time, for civil society, what's the use and usage of the UN system? And specifically, my question to Shima is, what do you think for Iranian women, and of course it's different, it's not just the one subject, what is the use and usage of the UN system when Iranian women actually sometimes cannot get visas simply to go to to Geneva and to speak with, for example, treaty bodies, which is like, truth of a lot of people who are outside of the global north. And then maybe for UN experts, the question is, do you think that civil society and Iranian women really have access to your system? And maybe if there is one thing that you would be able to change with all the resources in the world, what would you change to be more open for women as rights bearers, as active subjects?
Thank you.
Well, amazing question. Interestingly, even when we are talking about women's rights in Iran, we still don't have jurisprudence on Iran. You see, like we just have a couple of paragraphs in some of reports that we can refer to and speak about why women's rights are being violated in Iran. So that's how human rights reach in that part of the board. And I think it's a very sad part of this issue. So I think the question is really how UN is helping that society. We had a very good discussion about this, and I think it's very difficult to think about it. So, for example, to see a repression that was happening 30 years ago, for example, in terms of execution, of course, it's less now, and I think this human rights system worked to some extent to do political pressure on that system that do less execution, I would say, fewer execution. But also in a bigger image, does this system help that to stop this repression, to bring human rights, to bring democracy? I really think it's a no, and I think that's why when people go on the streets, they don't chant on the women UN. They rely on themselves and their power to win this war. I think.
I'm happy to also address that point before we move to the others, or
yes,
we can do it in another
please.
order. So there is a lot of literature about human rights in Iran. If you look at the UN documentation, 20 years ago, I finished my PhD and I was looking at the UN human rights documentation and the case of the Baha'is in Iran. So, just one aspect of it. You could have, for those that are researching or thinking of research topics, you could write your PhD on child executions, disability, women, and Iran, right? So, but there isn't jurisprudence because Iran doesn't allow for individual complaints. So, it hasn't ratified two key treaties. Well, more, but especially Convention Against Torture and CEDAW. It hasn't ratified it. And there's quite a history, an interesting history and interaction in the efforts within the country and outside to encourage ratification. But even of those treaties that it has ratified, it doesn't allow for individual complaints. So therefore, we don't have jurisprudence. So that, I'm an independent expert, so I don't need to defend the UN. But, the UN's hands are also tied. Okay. Now, have there been pertinent recommendations? I was looking at my predecessor. He visited the Special Rapporteur on Freedom of Religion and Belief. The last one that visited Iran was in December 1995. Look at his 36 recommendations. They are still applicable today. In fact, more applicable because the situation has deteriorated. It's worse than it was at the time he wrote. So Professor Abdul Fattah Amor's recommendations are still valid. So, has the UN, the special rapporteurs and treaty bodies been irrelevant? No, they have made really good. Some of them, when there has been an interaction, they've been quite discerning and have made recommendations that the state would have done well to adopt, but they didn't. Okay, so what are the UN offices doing within the country? I don't have that information, but from what I see from the charter-based bodies and treaty-based bodies, it's not through lack of trying or making pertinent recommendations, but the state hasn't had a listening ear, if we can generalize it in that sense. There have been two major successes in relative terms or in UN terms regarding Iran just in the last few months. Iran has been made to give up being on the Commission on the Status of Women, which is meeting now in New York. That has never happened before. I'm not saying it's good enough for people who have suffered for 43 years or whose children are taken off the streets, killed and raped and imprisoned and given 16-year sentences. Of course not. But I'm just saying in terms of UN processes, that has happened and a commission of inquiry has begun on Iran, which is currently has a call for submissions to it. Is there enough? I would just hugely generalize and say there isn't a huge trust in the UN amongst the Iranian youth. But on the other hand, there is a huge trust or call for human rights. If you look at the high-level segment speeches just last week, a lot of them said, drew hope from the fact that on the Iranian streets, people are claiming their rights. So, there's something there. Ultimately, even if we look at apartheid South Africa, it's within the country that change comes. But have these, could the voice be stronger, sharper, faster? I'm sure it can be, right? But I think the mechanisms that we have also, what is their connection with the ground? When there's a UPR, the states should have a national consultation. Do they have an open national consultation in Iran that is open to all and nobody will suffer consequences for participating? There's neither a call nor would it be free, right? Mm-hmm. Or, they held a conference in Iran and they forbid two religious communities to be part of the world conference. So, there has been lack of cooperation. Let's just put it in those two words.
I just say that I meant the literature on hijab, like the hijab.
Oh, absolutely. But also other jurisprudence. The system can't produce the jurisprudence because
I mean, but as we said, the hands are tied. Like there is not enough way of cooperation between the UN and the country.
Okay. Marsha, you had.
Perhaps I could pick up on a couple of the specific points that were raised around the room. And one was the very good question of whether or how the context is considered in committee decision-making. And of course, the committee does look at the context, the political context, the general the economic context. But in this case, in these two cases, the argument that was being put forward was that there had been terrorist attacks in France. And so that was a legitimate justification for banning covering the face in order to be able to identify those responsible for terrorist attacks. And the majority of the committee, there was only one person who dissented on this point. The majority of the committee, of course, didn't agree with this reasoning for all of the reasons I've said. In fact, the suggestion was actually quite, many of us strongly disagreed with it. That this is why you have to impose a blanket ban. So we did consider the context, but as a result, we didn't change our decision because this would be, still disproportionate, and the assumption behind that reasoning we couldn't go along with. Patricia Schultz, a former member of CEDAW, we're fortunate to have her here tonight, has made the suggestion of two committees working on a general comment together on privacy. And I guess, we know that behind the scenes, different committees contribute to general comments of other committees. These general comments are, first of all, decided on themes that are timely or pressing or topical at a particular point in time. And they also give the committees an opportunity to detail or elaborate the requirements on a state party, to give guidance to states on how they should protect that particular right. So to go beyond the words of the covenant into more detail and examples. And I don't mean to suggest that we are going to do general comment on privacy, but this has been suggested to us. There really are two now, and one is privacy, given the relevance in this day and age with surveillance and other concerns. So this is something that I think is entirely possible. There would be nothing stopping us from doing a general comment on privacy together with, for example, CEDAW. In fact, I think it could greatly enrich a comment that we would prepare. The idea that has been raised by another participant in the room, how far we are, the access of rights holders, the access of women to come to the Human Rights Committee, to access all of the mechanisms. This is something that has concerned me since I joined the committee. And there are ideas for addressing that. And one of the ways to do that would be to bring the committees closer to those who really rely on the committees in civil society, rely on them tremendously for reinforcing their concerns about human rights violations in their own countries, and also for making recommendations to raising those, flagging those with the states that we dialogue with, and then make those recommendations to the state so the state can follow them up and we check on the follow-up. So one idea that we have internally discussed in our committee, and Ibrahim knows about this well, is moving some of the sessions from Geneva to the regional headquarters of the UN, where we still have the UN presence, the UN security. We're not compromised by being in a particular country, because we would only be going to countries then who invited us. And it could be quite compromising also, depending on the situation, the context in the country. It's entirely feasible, in my opinion, to hold these sessions in regional headquarters of the UN, so that then countries could come from the region to report on their human rights progress, and civil society could come and engage with us and tell us the situation from their point of view, so that we can probe the state party about the actual situation in practice. There's also another benefit, and this links in a way with the UN system and the point that's been raised about why is the UN in particular countries like Afghanistan, when the situation is so egregious. And that is those UN presences at the regional level, they have programming ability. They have also budgets. So if they were to be engaged in following up on the recommendations that the Human Rights Committee and the other treaty bodies make, that would be a powerful force for change, because they could say, okay, the Human Rights has recommended that Afghanistan change its judiciary, for example, and reform the judiciary so that there would be rights of access and recourse for people in the country. A UN agency could then take that up and develop a program to do just that, with funding that they have for programs in the region. So there would be, in a way, a catalyst for those parts of the UN at the regional level now that don't engage much with the treaty bodies to then go forward and help us do what we want to see, and that's follow-up to our recommendations, not just making the recommendations, but follow-up. And follow-up that can then be monitored by those in the UN who are working on the ground. As far as why the UN stays in Afghanistan, I'm not going to address that now, but it seems to me that it raises the same sorts of issues that sanctions do. Because who would suffer most if the UN left? I think we have to take a close look at all of the things that the UN is doing in Afghanistan. And I agree with you, as a matter of principle, it seems contradictory that the UN remains when the situation worsens day by day. But how many people and women would suffer if the UN left Afghanistan? The system also has a responsibility to stop the repression. The UN reps there, the heads of the UN, to speak truth to power and really advocate for protection of human rights. So whether they're being successful in that role is another matter, but I'm not so sure withdrawing is, even if it's justified based on principle, would be the best solution for rights holders in the country.
Thank you. Thank you very much. I'm afraid we could go on for a very long time with this discussion. It's been great to hear all your answers and also all the questions that, were pointing to different direction, and I think expressing once again the complexities of the issues that we've been discussing tonight. I want to thank again our panelists for agreeing to come here and to speak to us from their different perspectives and mandates. Also the audience in the room and online for joining us and listening in, and also for engaging in the discussion. If you want to stay updated with our activities, please subscribe to our newsletter, check our social media. Thanks again for being here, and there is a cocktail waiting for us next door. We can still chat about this topic next door, and thanks again, and see you next time. Thank you.